You do solemnly swear the testimony you are about to give in this action shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do. In the beginning, he was scared for a year of a black Dodge Ram, thinking that Johnny and Destiny were coming to get him. It took 2 years to get him to sleep in his own bedroom.
Page 7, Your Honor.
Page 7, case C 348-747-2, State of Nevada versus Destini Woodruff.
Good morning.
Good morning, I'm Michelle Jobe, running 575
Good morning. So I have reviewed defendant's motion to modify conditions of release, the state's opposition, and the state's supplement, and welcome arguments begin with Mr. Draskovich.
Briefly, Your Honor, as you can see in the supplement, the state lays out alternative positions. Initially their position is no, and then the alternative position is that in the event that the court lifts the blanket no contact order, that my client follow the procedures laid out in the Red Rock Counseling Report. That's basically our position. We are not asking for carte blanche contact with the subject minor. We're asking the court just basically your order concerning the contact follow or be in conjunction with that which was in family court. Obviously, they can raise that issue before the district court judge there. My client he's obviously happy with those procedures, will follow through with those procedures. So we're just going to ask that your court, that this honor, order her to have contact in accordance with that laid out in state's opposition, their second position.
Thank you. Anything from the state?
I would note that the father is present and he would like to address the court based on his rights under Marcy's law. I would note that we obviously take the first position of no contact. I want it to be very clear, regardless of what happens.
So if I may, can I pause you a moment and ask you a question? For me, it probably would make more sense to hear, but I don't know if I'm, violating some rule or something. Maybe hear from the father first and then the state.
That's fine.
That's okay.
Come on, sir.
You do solemnly swear the testimony you are about to give in this action shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Could you please state and spell your first and last name for the record?
Okay. Go ahead.
Thank you, Your Honor.
Yeah.
My
And you
concerns
consider stand either.
okay.
Either one's fine by me.
My concerns, Your Honor, is over the last 2.5 years, he has made tremendous strides in his mental health. In the beginning, he was scared for a year of a black Dodge Ram, thinking that Johnny and Destiny were coming to get him. It took 2 years to get him to sleep in his own bedroom out of fear that they were going to come and take him away. I've taken him to counseling. I've done everything possible to help him get over these things, and he's finally starting to get there. And I'm worried that reintroducing this is going to set him back. Thank you, Your Honor.
Thank you. Okay, Ms. Jobe, go ahead.
And that's part of.
And you can stay there or go back. Either one's totally fine. Okay.
That's the reason why the first position is no contact. Is the state doesn't want to be in a position to advocate for a situation that negatively affects the child. And the state's concern is that if contact were to occur, that's what would happen. But I'm also understanding there is a lot of time left in this child's minority. And so There may be a time where contact becomes appropriate, and the state's position is if that's the case, then the very strict structure outlined by Red Rock needs to be followed. The mechanisms for that to happen are not yet in place. And I would also let the court know there's no open family court case as it specifically relates to this child, for there to be a family court judge to issue an order that follows this or has any type of supervisory situation if the court allows for some type of contact. Regardless of either way the court decides, whether it's maintain as to Destiny or to have those safeguards, I guess, put in place and that process be followed as it relates to contact between Destiny and the child at issue in this case, the state also wants it to be abundantly clear if any contact is allowed for Destiny, that no contact remains for the co-defendant, John Woodruff. And that whenever Destiny, if she does have contact with the child, that cannot be done in the context where the child may be exposed to John, where John may be discussed, or where he may be put on the phone or FaceTime or anything else like that, in order to ensure the safety and the well-being of the child. And the other concern that's been underlying this entire case has to do with the fact that both of them were law enforcement at the time this occurred. So we just want to make sure that there's an understanding that they should have known then. And so any rules by the court, it needs to be very, very clear they have to abide by them and follow them to the T.
Thank you, Mr. Draskovich.
Any contact it's understood will be in a therapeutic setting and overseen by the experts. If we were to file anything in family court, their response is going to be, well, there's a no contact order. This issue can't be decided. So basically, this is a condition precedent for them to begin that process if they see fit in family court. So it's obviously in this minor's best interests. I know he misses mom. We're not asking for any contact with the co-defendant. This motion solely concerns Destini Woodruff.
Thank you. So, concerns I have, obviously the underlying crime, but in addition to that, safeguards, when I was reading the motion, well, who is, advocating, if you will, on behalf of the child who's the one, subject to the order, right? I mean, let me walk that back, not subject to, protected by the order. Miss Woodruff's obviously the one subject to the order. I have concerns about safeguards. How am I or parole and probation, going to enforce, even the alternative mechanisms? And for better or worse, I'm relatively familiar now with parole and probation, and, they do a great job, but a lot of times they're overwhelmed with their amount of work and things like that. The burden right now is on Miss Woodruff to show, hey, there's no reason for the protection, or there's, good cause to remove it, or here's the way that you, judge, can, protect the interests of the child who was the victim. Oftentimes there is a family court case in place where I say, okay, go to family court and whatever. And I don't have a lot of experience, candidly, you know, with child protective issues. So I'm going to deny for all those reasons without prejudice, defendant's motion to modify conditions of release. Certainly welcome to rehear it at any point in time. What I would suggest, hey, be more detailed in your motion. And hey, we talked to X, we talked to Y, here's what they can do, those types of things. But again, you have the underlying crime, which is heinous, and then you have, you know, I am not going to subject a child to re-traumatizing, potential re-traumatizing, and Ms. Woodruff has a burden of proof and just hasn't met it right now.
What I'm going to ask, and I'm not representing her in the DFS case. Her counsel in that matter is going to. I know it's not open, but they're wanting to reopen it or address.
There's no legal way to reopen that DFS case.
And I don't know anything about family law. So, I mean, but go ahead, because she cut you off.
We anticipate, and like I said, I'm just trying to get ahead of this because so much time's gone by and there's certain presumptions that come into play. I want them, in the event that occurs, to say that the court, that Your Honor wants to know an anticipated direction in that matter, as opposed to just a blanket no contact. Because again, anything they were to initiate their response is going to be there's a blanket no contact order, it said.
I don't know that that's true, though.
I actually agree with Mr. Draskovich,
Oh.
but there's two sides to the house over there. There's the DFS side, which that case is closed. I don't know of a legal way to reopen that case, particularly based on how that case was closed as it relates to the victim in this case. The other side of the house is custody and divorce proceedings, and it's often the case, as Mr. Draskovich represented, where they won't do anything while the criminal case is pending.
Well, look. I mean, so is that the state's way of saying that there's no way that the defendant can renew this motion?
No, there's a way
Okay.
that the defendant can renew the motion here, I believe. With some of the specifics, I believe that things can be put in place where decisions may be deferred pending what happens in criminal court, and I think the best option for anything to be changed or done or moved would be after the sentencing date.
No? And,
It's January 17th, I believe.
Correct.
okay. Yeah, and I mean, I wish either of you had said that before, but we can add that to the reasons as well. I mean, you know, it's fair to say, let's see if sentencing actually goes forward, because as we all know, sometimes it doesn't. And see what conditions are put in place at sentencing. Again, it's without prejudice.
Okay, and just so the court and the state where we anticipate readdressing this matter on January 17th, assuming we go forward.
Yeah, and if you want to file a memorandum that lays out some detail for me, happy to consider.
Thank you very much.
Thank you.
Thank you.
Thank you, sir.